So welcome to another 2TG's webinar. We will probably have some time at the end for questions if you want, but if not, most of you probably already have my contact details. You can always ask me questions, and in the video when we send it out, my details will be there anyway. And so the title of this, as you all know, is Mediating Your Way Around COVID-19. Some of you may have seen that a few weeks ago I penned an article by the same name. If you're on Chamber's list, you would have received it by email, and if not, you may have seen it on LinkedIn. If you want it, of course, I will send it to you. And the strapline I had for that and for this talk is remote mediation, if not now, when? And as with the article, this is not a how-to-do webinar. I'm not going to spend the next 30 minutes telling you how possible it is to mediate remotely. I'm sure you have received many instruction manuals via email on how to do it. The very fact that you've all logged into this webinar is proof that for all of you, it's possible. So what is the webinar, if not a how-to? It's a why-to seminar. Why you should be remotely mediating now, as the title says, and if not now, when, or the question. But for those of you who have read my article, I hope to be covering a few other things that are not there, and perhaps a slightly different perspective on how I saw things only a few weeks ago. And it's a very changing scenery out there, and it changes ideas. Anyway, and one of the reasons is that so much has happened in the last month. The article's content, I think, remains valid, but experience and experience of doing more remote mediations have caused me to refine some of my views, and I'll come back to that. So although it's not a how-to-do talk, I hope you'll indulge me if I spend a little bit of time just talking about my remote mediation experience. Yeah. And I actually had my first remote mediation on the 18th of March, so a week before lockdown. The reason for it being remote was COVID-19 related, and it was that one of the parties, or the participants, had been recently been through chemotherapy and stem cell therapy, and had been advised not to meet with other people, especially given the growing concern over COVID-19, as there already was then. And it actually was a semi-remote mediation. Some of the participants were there, some were at the other side of the screen. And I admit to, when I was told that one of the parties could not participate, to having some hesitation as to thinking, well, can we really go ahead? I wondered if the parties would take it seriously, if it would be possible to communicate through a screen efficiently with the parties. And on a personal level, I was concerned as to whether I would be able to bring into the mediation my mediation style, my personality that I think, or at least I hope, is a trademark of my mediation. And I think they were all valid preconceptions and fears, but not a valid reality. The mediation was a success. It was totally doable. Settlement was achieved. Documents were drawn up and they were signed digitally and remotely. And I came away actually confused as to why we hadn't used it before. So any of the worries I had gone. Subsequently, over the last 6 weeks, having done a few remote mediations, for me have just shown me how doable it is, how it works, and how, although not perfect, as indeed regular mediation isn't always perfect, it provides a complete and workable platform to conduct a mediation. So in short, it can be done well, but the real question for me, the one which I posed as part of this, it is why mediate now? The remote mediation bit, is a given. Or if we're going to mediate, we have to do it remotely in any event. It's the only way. So the question is why now? And the simple answer to that is why not? As a mediator, as with all mediators, I'm sure there's many mediators are listening, it's been my mantra, it's the mantra of most, if not all mediators, that mediation is always the right dispute resolution choice. It's always the right option. But why now? What I'm really getting at is why not wait until this situation, this COVID-19 situation has passed? And on a practical note, the opportunity, my simple answer is the opportunity for lawyers, for solicitors, for barristers to work on disputes and cases in the same way as everyone did only a few weeks ago, is not totally open to you. It's clear to me, speaking with clients, that some are, and this is both solicitors and barristers, some are having great experiences, some say they're almost working or even working normally, and some are not. But most are finding challenges along the way. For example, it may not be possible to obtain all the information you need to ensure your disclosure obligations are fulfilled. You may not be able to create perfect witness statements as you would like to. Experts are going to find it more difficult to get site visits, to see relevant people, to obtain evidence, to do perfect expert reports. And there's endless practical hurdles along the way. But the thing I'm hearing most from solicitors and barristers is that the sense of urgency of moving cases forward seems to be missing, at least in part, and in some cases a lot more. The threats of, if you do not do this, we will do X, Y, and Z are falling largely on deaf ears. Correspondence is going unanswered. And in some respects, deadlines are being ignored. And one attitude, prevailing attitude, seems to be that we can sort everything out when all this resumes, when everything goes away. And then there's the courts, and one can only pay tribute to the courts, the court staff, and indeed the judges, who do appear to be doing quite an amazing job. The court system, the High Court automated system, appears to still be working. There are stories coming out of the county court, sadly, that they're more paper-concentrated systems or administrative systems appear to be floundering a bit. We see that trials have happened. Big trial in the commercial court, the National Bank of Kazakhstan against New York Bank was the first commercial court case ever to be tried on a complete remote basis and was said to be a success. And there's been reports of adjournments being refused, where those adjournments have just been solely on the basis of COVID-19. But those are the ones making the headlines. The reality is, however well judges and court staff are working, they are not working to the same capacity as before to deal with interlocutory matters. And that's what many involved in litigation disputes will feel it is essential to keep moving the dispute on. And one thing for sure is that backlogs are already happening. And that means delay, and will continue to mean delay. So in short, business is good, but it's not necessarily business as usual. And as we've seen, it's unlikely to be for some time. And that means delay in proceedings and probably greater delays as we go back to our old normal, whenever that is. So sort of dwelling on that, going back to my question, why mediate now? When I wrote the article, I was keen to get it online, and I procrastinated a bit, and I didn't get it out for 2 weeks. So I think it went on about the 8th of April, and we've been in lockdown for about 2 weeks. And what I had in mind when I posed the question, why mediate now, was why mediate, why wait to mediate, do it now during what had become our new normal. This what I saw as being a relatively finite period of time that needed to be covered using a remote mediation. And then I thought, as we all did, if we went back 6 weeks or so, that we then get back to our old normal. And I guess I had in mind at the time primarily those mediations that were already booked more than anything else. So now we find ourselves, we're coming up to the 6-week anniversary of being in lockdown. And the realization is that whatever the government determines in respect of us getting back to normal, it will only be us getting back to as normal as possible. We may no longer, whatever time it is, and it's not going to be next week, but we may no longer be in our current lockdown or restricted movements as we now are. But I think we all know that we're still going to be queuing to get into Tesco's at 2-meter distances. If we are allowed to go to restaurants, we may well be sitting with someone from our household, but there will be no one on the table next to us. We will probably not be going to the cinema or theatre for some time. But again, when we do, we're going to be spaced out in the cinema or theatre. And we're still going to be expected to keep our 2-meter distance when walking or exercising in the park. And so with that in mind, I think it's very unlikely that we're going to be sitting in small, medium, even larger conference rooms in solicitors' offices or wherever, mediating face-to-face as we previously have for some time. So unless we move to outdoor mediation, which is perhaps a thought and one you heard here first, and which I claim the branding on, maybe Andrew Miller, Outdoor Mediator. Unless we're going to do that, I think that in answer to my own question, why mediate now, my response is, why would you not mediate now? And that means mediating remotely. Effectively, what are you waiting for? Because whatever the hurdles are within the legal process, those same hurdles do not apply to mediation. And those same hurdles will not prevent you bringing a matter to mediation. All you need is the consent of your clients and the cooperation of the other side. And what are you selling to your clients? You're selling a chance to bring their dispute to an end now, to achieve certainty in an uncertain time. Because the option for them might be to wait until all this passes, until the courts have caught up, until their case can get on, but with no guarantee when that will be, and with no guarantee, of course, as always, as to what that outcome will be and whether it will be any better than mediating now. Will it be better in 6 months, 1 year, 2 years? We may be seeing disputes now that aren't heard for 3+ years. We all know that a mediated settlement may not be the perfect anticipated end game that all litigants dreamed of at the start of litigation. But it is getting to the end of the road, and getting to the end of the road now. And so for me, the real reason for not delaying is that the future remains uncertain. Whether you're an individual, a business, small or big, or a huge corporation, you simply cannot predict what is going to happen. If you're a claimant, do you know if the defendants will still be in existence when all this is over? Will they be able to satisfy any judgment you get down the road? Defendants, are claimants going to become more entrenched the longer this goes on and keep you in litigation for longer than you anticipated for years to come? There are just so many reasons to bring existing disputes to an end. And of course, as with all disputes, you most likely will resort to settlement in any event at some time. So why not now? And that brings me to the second point. And it's the second question that I posed in my article. And that was, but what if it's too early in the legal process for a successful mediation? And that's something I hear all the time. It's raised in the good times, it's raised in the current time. And I would deal with it here as I've dealt with it before. Those of you who've heard me speak on mediation will know that I'm an avid proponent and supporter of early stage mediation, or ESM, as it's becoming more familiar. And early stage mediation simply does what it says on the tin. It's not a different formal process. All it is simply getting to mediation sooner rather than later, and effectively as soon as possible. And I know as a mediator, and I knew it as counsel, that from experience, a successful mediation does not depend on the parties having obtained witness statements. It's not dependent on the parties having exchanged expert reports. And it's not even dependent on the parties having started proceedings. It's all about parties focusing on why they are in dispute rather than focusing on the dispute itself. And I often joke that lawyers often forget that the best interest of a client is being able to never see them again, or at least not in respect of that piece of litigation. Settling a dispute is the best present that any lawyer can give to their client. And although there will be times when mediations fail, because not all mediations are successful, and although there will be times when it's too early to get a settlement, I firmly believe it's never too early to have parties talking about their dispute and the reason why they're in dispute. And that's even more so now, currently, given the great uncertainties that we have. What this gives, what this time gives, what this opportunity gives is an opportunity for lawyers to lead their clients to settlement discussions sooner rather than later. And if you do manage to get a client to a settlement through mediation or otherwise, it's highly unlikely that that client is going to criticize you for failing to ensure that they stayed in the litigation for several more months of years. I think it's very rare that clients ever complain about that. And so that deals with the second point. It's, in my view, it's never too early. And so a third question that I posed in my article, and it was a real question posed to me by a solicitor friend, and that was, post-COVID-19, don't you think I will need my existing caseload? And it was quite a few weeks ago that was said. My feeling then, and my feeling even more now, is as a lawyer, whether you're a solicitor or barrister, that should be the last of your worries. What I think is quite clear now is that there is a backlog already, but in addition to that, there is already a ton of new work that is coming up, which is going to add to the backlog. So in respect of existing disputes, existing work, unless everything is mediated, which of course it won't be, there's still going to be quite a bit of work. But then looking at the new work, which, as I say, is already starting, every single type of commercial dispute is probably going to be there waiting to be fought out, from sale of goods to state immunity, if you're thinking about suing China, as you know, some of the states in the US already have. Insurance claims, they're already going through the roof, and in particular, business interruption claims. I'm sure many of you have seen the articles in newspaper about Hiscox and the possible class action that there's going to be. And that will be, I'm sure, one of many against insurers. Sadly, insolvency. The estimate is the longer this goes on, the higher percentage there will be of businesses becoming insolvent, and that will lead to litigation in respect of those insolvencies. There may be claims against the government in respect of failing to honour some of the promises that they've made during this process. Landlord and tenant claims, already there are many issues between landlords and their tenants. They are liable to proliferate, including possession claims. Debt collection is going to be there and is going to be in huge numbers. And then, of course, there's the force majeure clause being tested. One can only see from one's email just how many lawyers, solicitors, barristers are writing articles about that, what it means. And those clauses are going to be put to the test very, very much indeed. Yeah. But in terms of the future, and in terms of not being concerned for the future, you don't have to accept my word on it. This week, an organisation, the British Institute of International and Comparative Law, have produced a concept notes. And the title of it is The Effects of the Pandemic on Commercial Contracts and Legal Considerations in Mitigating Mass Defaults. That research is being led, or certainly being contributed to, in a very large way, by two former Supreme Court presidents, Lord Phillips and Lord Neuberger. And some of you may have heard Lord Neuberger on this week, and it was Monday this week, on the Today programme on Radio 4, talking about the British Institute of International and Comparative Law's paper, and talking about what is fears for the future of the legal process in the UK. And what Lord Neuberger said on the Today programme in relation to the effect of Covid-19 on the courts and litigation was in response to a question when he was asked was what he wants to see happening. And what he said, and I'll quote from what he said, was, well, I think the first point to make is that we have to be ready for an avalanche of cases. It may be that they won't come because one can't be certain what will happen, but as we've learned from this crisis in other fields of health and social and economic, we have to be ready. And I think the legal world owes a duty to the rest of the world to prepare itself up for a large number of cases which may clog up the system and may sometimes lead to unsatisfactory results, and which can perhaps be improved by putting forward some suggestions. Now, Lord Neuberger was concerned with two things. The first was the courts being inundated and not being able to cope with the backlog and the avalanche of new cases. The second was the effect that this was all going to have on the economy. Not the backlog in itself, but the actual litigation itself, and the effect it would have in the economy if parties seek, by the legal process, to enforce all of their legal rights. And what Lord Neuberger was saying was this might in fact bring an end, firstly to commerce between those parties as it was before, possibly to the end of one or both of those parties being in existence, and therefore, and this was his real fear, even greater harm to an already damaged, fragile economy. And so, emphasising those fears, he was asked, well, then what is your suggestion? And when pushed on that, he said, well, one thing that immediately comes to mind is that instead of going to court and having an expensive and uncertain piece of litigation, parties may be sensible to consider mediation. So, assuming Lord Neuberger is correct, as he usually was and of course still is, and there's going to be an avalanche of cases, going back to my question, post-COVID-19, don't you think I need my existing caseload? The answer is probably no. You will probably not. and you're best to shed it now, which comes back to the beginning, mediate now. But it also raises a different point, and I think it's a different point to what Lord Neuberger and in the paper, what Lord Phillips is talking about. Because what they're concentrating on is the position of practicality. Practicality that the courts will not be able to cope, so don't bring your cases to us. Practicalities, or in terms of economics, if you do fight all these cases, you may not have an economy when you come out of it. So please don't break the economy. And one of the primary solutions to this was, for those reasons, go to mediation, consider mediation. But I think there is another fundamental point that has formed, certainly for me, since I wrote the article, and over the last 6 weeks, seeing what's happening. And that fundamental point is why mediation is appropriate for the disputes that are coming down the road. And if we pause and think about disputes, in almost all disputes, and I find it hard after 30 years of practice to think of a dispute that doesn't have this, you have a party who thinks they are right and that the other side is wrong, and vice versa. You have good guys on one side and bad guys on the other side, and vice versa. What is always said and thought is one side should not have done what they did, one side should have done that they did not do, one side shouldn't have let this happen, etc. And crucially, in at least most disputes, if not all, the other side is effectively the enemy. And that may be putting it strongly. If they're not the enemy, they're at least not your best friend. But now we have something completely and utterly different. Now, disputes coming as a result of this, of the COVID-19 situation, for most parties in dispute, they will have something in common. They will have a common enemy, and that enemy will be the coronavirus, COVID-19. In most cases, what has happened will not be because of any fault on the part of one side or the other. The fault will be the situation that neither side caused and that neither side could have prevented. And what better basis is there for mediating a dispute where the enemy, using the word again, is totally outside the mediation room and even the remote mediation room? And parties always want a solution that gets them back to where they were. They want a solution to be working, especially in this particular case where COVID-19 has caused it. They want a solution very much that will allow them to be in the status quo where it was, where it all went wrong. And mediation allows that there is that ability to try and create that solution, which a straightforward legal process will not. And only mediation is best suited to achieve this generally in disputes, but certainly in the coronavirus COVID-19 disputes that are coming down the road. And so, in short, mediation not only has the ability, it has the capacity to find the solution to the damage that has been caused to both sides. And although, as I read, Lord Neuberger and indeed Lord Phillips in the press release that was released by the Institute was encouraging mediation, it was still using the line of encouraging it as part of the legal process. And so going back to one of my earlier questions, it begs the question of why not before? And I think if ever there was a time to mediate, it is now, and will be when we get back to our partial normal reality. But if ever there was a time for early stage mediation, this is it. And so it appears, at least to me, that there is the answer to my rhetorical question, if not now, when? Well, there almost isn't an answer. It has to be, the answer has to be now. So perhaps simply now and for quite a long time going forward. So thank you very, very much. Thank you all for attending. As I say, we do send out a copy of this to anyone who wants. If any of you have any questions, then please do send them directly to me by email or via Chambers or on LinkedIn, and I will be posting this on LinkedIn as well. So thank you very much. Have a wonderful and safe weekend, and I wish you all very, very well. Thank you very much.